Good day, everyone. We're now going to discuss some of the possible questions that may come up in the subject of civil law for the 2022 bar exams. A disclaimer, these questions are based on our own intuition, based on our own forecast, our own opinion, and it did not come from any other source. So please take it with a grain of salt. Okay, so let's proceed. Melvin and Jan met in 1996 in Southwestern University in Cebu. They became sweethearts but ended their relationship in the year 2000. Jan began dating a co-worker. Melvin and Jan did not have any communication with each other for months. On 2001, Melvin asked whether Jan did actually went out with a co-worker. The latter denied and insisted that no one has touched her. Jan and Melvin got back together and the latter learned that the former was pregnant. Jan gave birth to a girl in 2001. Despite having doubts as to the paternity of the child, Jan and Melvin wed in 2004. In 2010, Melvin took a DNA test with the child. The results revealed that there was 0% probability that Melvin was the father. Melvin sought annulment under Article 45, Paragraph 3, in relation to Article 46, Paragraph 2 of the Family Code. Does Melvin's claim for annulment have merit? No, the petition to annul the marriage under Article 45, Paragraph 3 in relation to Article 46, Paragraph 2 of the Family Code does not have merit because there was no showing that it met the requirements of the law that the wife must be pregnant at the time of the marriage and concealed the said fact. Article 45, Paragraph 3 of the Family Code provides that a marriage may be annulled for any of the following causes existing at the time of the marriage. Paragraph 3 that the consent of either party was obtained by fraud unless such party afterwards, with full knowledge of the fact constituting the fraud, freely cohabitated with the other as husband and wife. To constitute fraud that warrants annulment under Article 46, Paragraph 2, the wife must have been pregnant by a man other than the husband at the time of the marriage, and the wife must have fraudulently concealed the same. This is based on the case of Republic versus Villacorta. Again, in this case, Jan already gave birth to a child before they got married. So next. An order of award was given to Leung as a winning bidder in a public auction for a property in Baguio. Madio sought the cancellation of the award before the Bureau of Lands, claiming that the auction sale over the subject property was void because the notice of auction of sale was never published. The Bureau denied the cancellation. Is the Bureau correct? No, the Bureau of Lands is not correct in denying the cancellation of the auction sale because it did not comply with the publication requirement for auction sales. In a decision of the Supreme Court, it said that the failure to publish the notice of the auction sale as statutorily required constitutes a jurisdictional defect, which invalidates the auction sale of the subject property as well as the consequent award of the property. Based on the case of Heirs of Leung versus Heirs of Madio. In 1997, Urban Bank granted credit accommodations, which are called Ready Check Mortgage Lines or RCMLs to spouses Rodriguez, initially amounting to 5.9 million, with their Negros property and Makati property as security. In 1999, Urban Bank increased the RCMLs of the spouses Rodriguez to 6 million with a caveat that the account covering the Negros property shall be cancelled, and the existing RCMLs of the spouses under the account were also released. In 2022, Urban Bank merged with Export and Industry Bank. In the same year, spouses Rodriguez received a fax from Export and Industry Bank, reflecting a statement of account amounting to 2.3 million pesos. Spouses Rodriguez claimed that the said account was already cancelled under the 1999 RCML. Export and Industry Bank sent a demand letter to the spouses Rodriguez to settle the obligation. The letter failed to do so. Export and Industry Bank filed a petition for extrajudicial foreclosure. Is the extrajudicial foreclosure valid? No, the extrajudicial foreclosure is not valid because the spouses Rodriguez were not in default as EIB's demand was incomplete. The Supreme Court ruled in a case with similar facts that without a prior valid demand, the mortgagee creditor's resort to extrajudicial foreclosure is premature and thus void. For the creditor's demand to be considered valid, it must first specifically relate to the obligation that is due and demandable. Second, fully apprise the debtor of the amount due to the creditor, including any accrued interest and penalties imposed in the obligations. It follows that an incomplete demand, or one that leaves the debtor unable to make a valid payment, is ineffective and is insufficient for the purpose of rendering the debtor in default of the obligation, based on the case of Spouses Rodriguez versus Export and Industry Bank. Distinguish surety from guarantee. In a suretyship, the surety is principally liable as opposed to a guarantor who is only secondarily liable. A creditor may also go directly to the surety even without a prior demand on the principal debtor, although the latter may be solvent or otherwise able to pay. A surety's liability stands irrespective of the principal debtor's ability to perform his obligations under the contract which is the subject of the suretyship, based on the case of Tan versus Malayan. Francis filed a petition to change his surname from Santos to Rebilla, the surname of his biological father, Bong. His mother and Bong did not marry as his father had a subsisting marriage. His father married Patrick Santos, who eventually legally adopted Francis. The OSG opposed the petition, claiming that there was no compelling reason to justify the change sought. Rule on the issue. The court should rule in favor of the OSG because there was no compelling reason to justify the change of name. It must be stressed that a change of name is a privilege, not a matter of right, addressed to the sound discretion of the court, which has the duty to consider carefully the consequences of a change of name and to deny the same unless weighty reasons are shown before a person can be authorized to change his name, that is, his true or official name, or that which appears in his birth certificate or is entered in the civil registrar. He must show proper and reasonable cause or any convincing reason which may justify such change, based on the case of Santos versus Republic of the Philippines. Ellie donated their land to his grandson, Nick Jr., without the conformity of Adele, Ellie's wife. In February 2005, Ellie filed against Adele a petition for declaration of nullity of marriage on the ground of psychological incapacity. The trial court granted the petition and the judgment became final and executory in July 2005. Ellie died in 2008, and a year later an extrajudicial settlement among the heirs was executed. In 2010, one of the children of Eli and Adele brought an action of annulment of the donation of the land donated by Eli to Nick Jr. on the ground that it was prejudicial to her interest because it affected her future inheritance or legitim. Nick Jr. argued that Ellie, being a co-owner of the subject land, has the right to alienate his property. Is Nick Jr. correct? No, Nick Jr. is not correct because Article 493 of the Civil Code yields to Article 147 of the Family Code. Under Article 147 of the Family Code, neither party can encumber or dispose by acts inter vivos of his or her share in the property acquired during cohabitation and owned in common without the consent of the other until the termination of their cohabitation. In 1987, Arwen acquired titles for a 24,000 square meter property in Calatagan, Batangas, with a TCT issued in his name. Unknown to him, the property was a derivative of a title covering Hacienda Calatagan. The said title was annulled after the Republic filed a complaint for annulment of title, claiming that the original owners illegally included portions of the territorial waters and land of public domain when they prepared the composite plan for the Hacienda, that is from 9.6 hectares to 12 hectares. Now the RTC orders Arwen's TCT for cancellation. Arwen claims that he was not privy to the original reversion proceedings and such decision does not bind him, considering that he is an innocent purchaser for value. Is Arwen correct? No, Arwen is not correct because the doctrine of indivisibility of title for innocent purchaser for value does not apply when such titles were secured by fraud or misrepresentation. The well-settled doctrine is that the indivisibility of a title does not attach to titles issued pursuant to patents that have been secured by fraud or misrepresentation, inasmuch as the registration of a patent under the torrent system is not a mode of acquiring ownership and does not by itself vest title, but it merely confirms the registrant's already existing one. The certificates of title registered in the names of petitioners, not being indivisible, can be ordered cancelled, based on the case of Belisario versus DANR. Consent of the majority of the co-owners is needed prior to the sale of a common property. True or false? False. Prior to a partition, a sale of a definite portion of a common property requires the consent of all co-owners because it operates to partition the land with respect to the co-owner selling his or her own specific share therein, based on the case of Ulay versus Bustamante. Eulalio and Flora were married and owned properties. Eulalio sold one of their land without consent of Flora. The RTC invalidated the sale because of the lack of spousal consent and rendered the sale void. Is the RTC correct? No, the RTC is not correct that the lack of spousal consent is void, because jurisprudence states that the lack of spousal consent renders the sale merely voidable. Under the regime of the Civil Code, the alienation or encumbrance of a conjugal real property requires the consent of the wife. The absence of such consent renders the entire transaction merely voidable and not void. The wife may, during the marriage and within 10 years from the transaction questioned, bring an action for the annulment of the contract entered into by her husband without her consent, based on the case of spouses Cuenco versus spouses Bautista. What is the effect when the surviving spouse and the heirs of the deceased spouse do not liquidate the conjugal properties and keep them undivided? A co-ownership is deemed established for the management, control, and enjoyment of the common property. Since the conjugal partnership no longer subsists, the fruits of the common property are divided according to the law on co-ownership, that is, in proportion to the share or interest of each party, based on the case of heirs of Caburnay versus heirs of Season. In order for the presumption in favor of conjugal partnership to apply, what should be proven first? The party who invokes the presumption must first establish that the property was acquired during the marriage, because the proof of acquisition during marriage is a condition sine qua non for the operation of the presumption in favor of conjugal partnership. Based on the case of spouses Anastasio versus heirs of Coloma. What are the requisites for a valid divorce decree obtained abroad? Article 26, paragraph 2 of the Family Code applies to mixed marriages where the divorce decree is first obtained by the foreign spouse, second obtained jointly by the Filipino and foreign spouse, and third obtained solely by the Filipino spouse. Based on the case of Galapon versus Republic. What is action interdictal? It is a summary ejectment proceeding which may be either for forcible entry or unlawful detainer, for the recovery of physical or material possession where the dispossession has not lasted for more than 1 year and should be brought in the proper inferior court, based on the case of Heirs of Collado versus Gutierrez. What is action Pobliciana? It is the plenary action to recover the better right of possession or possession de jure, which should be brought in the proper inferior court or regional trial court, depending upon the value of the property. When the dispossession has lasted for more than 1 year or for less than a year in cases other than those mentioned in Rule 70 of the Rules of Court, based on the case of Heirs of Collado versus Gutierrez. What is the recto law? The recto law covers sales of personal property on installment basis. The vendor may exercise any of the following remedies. First, exact fulfillment of the obligation should the vendee fail to pay. Second, cancel the sale should the vendee's failure to pay cover 2 or more installments. Third, foreclose the chattel mortgage on the thing sold if one has been constituted should the vendee's failure to pay cover 2 or more installments. In this case, he shall have no other action against the purchaser to recover any unpaid balance of the price. Any agreement to the contrary shall be void, based on Article 1484 of the Civil Code. What is the principle of res ipsa locator? Res ipsa locator is a rule of evidence where negligence of the alleged wrongdoer may be inferred from the mere fact that the accident happened, provided that the character of the accident and circumstances attending it lead reasonably to believe that in the absence of negligence it would not have occurred, and that the thing that caused the injury is shown to have been under the management and control of the alleged wrongdoer. What is action reivindicatoria? It is an action for recovery of ownership which must be brought in the proper inferior court or regional trial court, based on the case of Collado versus Gutierrez. As a rule, when a general partner retires, dies, becomes insolvent, or becomes insane, it dissolves a partnership. What are the exceptions? When the business is continued by the remaining general partners, first under a right to do so stated in the certificate, or second with the consent of all members, based on Article 1860 of the Civil Code. What is the rule in the exercise of the right of redemption under the Personal Property Security Act? As a general rule, any person who is entitled to receive a notification of disposition in accordance with this chapter is entitled to redeem the collateral by paying or otherwise performing the secured obligation in full, including the reasonable cost of enforcement. The exceptions are: first, the person entitled to redeem has not, after the default, waived in writing the right to redeem. Second, the collateral is sold or otherwise disposed of, wired or collected by the secured creditor, or until the conclusion of an agreement by the secured creditor for that purpose. And lastly, the secured creditor has retained the collateral. This is for the practical exercises. This is a contract of lease of a personal property. Number 1 shows the title, second, the announcement, third, the parties, fourth, condition and terms, fifth, the signature, and sixth, acknowledgement. And first, the title, second, the announcement, know all men by these presents, third, the parties, that blank, the party number 1 or party number 2, third, parties, party number 1, party number 2, Number 4, state the terms and conditions. Number 5, the signatures, lessor and the lessee. And 6, acknowledgement. Complaint. Here's a copy of a complaint. Just look it over.